All right, we're gonna go ahead and get things started here. We got a few more people on their way. So today we have a legal discussion on the divorce and how that relates to real estate. And so we got a few experts here from different industries. We'll do some introductions here in a second, but has anyone here been through a situation where they're selling a property or buying one where someone's going through a divorce? Raise your hand. Okay.
Most, I like it, all
You
right.
get lots of questions from people asking, well, what do I do in this scenario? So instead of trying to give you guys some indirect answers, we're trying to give you guys the experts here in front of you. They deal specifically with family law and divorce. So we have a lot of questions we're gonna be going over. So the way it's gonna work is we will do introductions and then we'll go over, each individual has a certain topic that we're gonna be discussing. And then we'll take some questions from that after following that person's discussion as an intro. And then at the end, we'll open up to questions across the board, anything outside of that as well. So before we get started, at the end, we have Robert Buchanan with First Rate Home Loans. And Robert has done a couple deals since his time in the industry, right? How many years have you been in?
Well, I've been off and on in the industry since 1994. So I know.
Do you know what I was doing in '94?
You were,
I think second grade.
Yeah, I would say, yeah, you were in elementary school. Yeah.
Oh, you know,
Yeah, but back in the business, and so I'm a registered investment advisor as well, and have been since 2001. And I was a registered investment advisor full-time for the better part of 12 years. And came back in 2012 to the mortgage space because a good friend hired me away. And that was Axiom Financial. And one of my old coworkers is right back in the back there. So it's good to see her. But yeah, I've been with this for a minute and have done a lot of divorce loans and have some thoughts. Yeah.
Thanks, Robert. Next, we got Ryan Gregerson, and he is the owner and operator of RCG Law Group and 15 years of experience in law. If you want to give a quick little intro.
Yeah, so done divorce for most of that time. First year or so was a prosecutor, but divorced since. Opened up my firm 2 years ago. And we do almost exclusively divorce and family law. So I've personally done about 2,500 divorces, and as a law firm, our attorneys, we've done over 4,000. So we've done a lot, we've seen it a lot. We deal with real estate in divorce cases many times. It's very common, very frequently you're dealing with it. Joey just was today in the mediation. He's finishing up as he's walking into this class. And so real estate becomes a really key component when we're dealing with divorce.
All right, next we got Joey. Joey, you've been in the industry for a minute and you've been with RCG as well. Tell us a little bit about what your expertise are and where you focus with the group.
So I'm an attorney. I mean, that's my primary job. I oversee the attorneys at RCG. I oversee the operations. I also practice. So like I said, we sat mediation today for 5 hours. The main sticking point was the house that they owned together. That was the sticking point that we've been working on for 5 hours. So, yeah.
Okay, very good. All right, so first off, I'll introduce myself. I am the GM and I oversee education with Realty Path. And so my experience is I've actually ran into divorce quite a bit in the industry. We got a lot of agents who ask me questions about how this functions. There's a lot of issues you can run into, and we're going to review all those items today as well. But to get started, we're going to talk about property ownership and division. And so I'll let Ryan kind of give a breakdown. And again, once he's done giving his spiel for the next 10 minutes, then you guys will be open to ask questions for Ryan. So Ryan, take the...
Yeah, I mean, I'm gonna take some liberties here. Give me an idea. Is everybody here an agent? We're all agents at Realty Path? Okay, I see nods of heads, yes, mostly. I see a hand there, no? Yeah, okay, perfect. Okay, so good, that's good context for me, kind of know my audience that we're talking to. So look, when it comes to division in the state of Utah, have you guys heard of community property? Is that a term you've heard of before?
In Texas.
Okay, Texas does have community property. So do a few other states like California. What do you guys know about community property? Yeah.
That if you are doing a loan for someone and the wife's not on the loan, but they are married, you still have to count their debts against all of their income or just the husband's income. So you have to combine a lot of their assets and their their debts,
Even if she's not on.
even if she's not on the loan.
Yeah, with community property, when something's acquired during the marriage, there is a baseline assumption that it is community. Like it is jointly owned by the parties. That is the assumption. That's the key thing to start with. And that's not the case when it's not a community property state. Utah is not that. And that might be confusing, and we'll talk about why in a second here. Because Utah is, we call, in divorce anyways, an equitable distribution state. So what the heck does that mean? You guys ever heard of something called a court of equity? You guys heard of that before? Any idea what that would mean, a court of equity? Right, there's a court of law, right? It's really the same thing. When you have a court of equity, what do you think a court of equity is trying to do? Yes,
Divide up assets.
but how? In an equitable fashion. What does that mean? Whatever the judge freaking thinks, okay? Like literally, that's the standard, okay? And so there's a lot of discretion that's given to the judicial officer in an equitable distribution state. That does make it quite a bit more complicated, right? Is it more equitable? I guess one could argue that it is, right? As opposed to, well, it's just straight 50-50. We're gonna ignore any other factors as to what should happen because it's community property, it's 50-50. But it does create a lot more potential for litigation. So let's talk about equitable distribution state like Utah is. So when a spouse acquires something during the marriage, it doesn't automatically give the ownership interest to the other spouse like it would in community property state. Now, that being said, you probably have run into the situation though, that when someone's getting divorced, we got to deal with what that spouse's interest is, right? Well, how does that work then? It's because it doesn't spring into effect until it has to. Okay, so if you're gonna go do something as a married couple, but one individual is doing it with certain assets, they don't have to get to sign off or necessarily involve the other spouse. In a community property state, they do oftentimes, in fact, most of the time. But when it comes to division, equitable distribution in a divorce situation, they're gonna be dealing with what we have premarital assets and marital assets. Because then the court's gonna start determining what those things are. You guys heard of that separate property versus marital property? What is separate property? Anybody know? Somebody who doesn't. These guys don't want to speak up.
Maybe a car,
What's that?
autos.
My CDs.
Okay,
We were married.
the answer is that those would not necessarily be accurate. Okay, those are just assets. You're just naming assets, right? Yeah.
Property acquired before the marriage?
Okay, now we're getting somewhere. Property acquired before the marriage, right? Look, if John had a house that he had, and then he met his sweet wife and married her, that house that he had prior to the marriage is separate property. Because he had it before he met her, right? So of course it's separate property. What other types? You guys are familiar with any other types of separate property that could happen when you are married? Yeah,
Inheritance.
inheritance is separate property. That's also true. Okay? Anything else?
Would a business be potentially?
Only insofar as any other asset classification. So business in and of itself, no, it's not. It's a good question though. Something theoretically received by a gift. Okay, theoretically, if you receive a gift during the marriage, that could be separate property. I'm hedging, can you tell? Right, because gift probably is, but what's the gift? Have you guys ever run into a situation where you've got a younger couple and they want to buy a house and they need the down payment? And who helps them with that? One of the parents. But it's probably not both of the parents, right? It's probably one of them. And what do you have to get? Can they just give them the money?
A letter saying.
You gotta get a letter, right? And what is the letter gonna say? It's gotta say it's a gift, right? It's gotta be a gift letter, right? So you gotta turn it. You can't be like, oh, we're gonna maintain an interest in this. They'd be like, we're just gonna be like, no, you're not. That's gonna be a gift letter. Okay, so it's a gift letter, but what does the gift letter say? Well, this $10,000 down payment is solely and uniquely to John and to nobody else and to not to his spouse at all. And his spouse won't have any right. No, it never say that. It never says that. Okay. He says, yeah, it's a gift, right? It's a gift. These guys are gonna get this house. So that's a gift, but is it usually separate property? Almost never, right? Very fact intensive, comes back to equitable distribution, but almost never is it actually gonna be separate property, even though it's a gift. Okay. So we've talked about separate property. Now what about marital property? What's marital property? I heard some grumblings. Let's hear somebody loud. Yes, you started. I'm gonna make you.
Any property acquired during the marriage?
Okay, so property acquired during the marriage that doesn't fall into one of these other exceptions, right, is gonna be marital property. What else? You guys ever heard of a term called commingling? Ooh. So commingling happens when we have a separate asset that suddenly gets commingled with marital assets and then loses its separate property nature, right? It transforms and then becomes marital property, even though at some point in time it may have been separate property, right? So that's what we're looking at. There's all these different nuances. Yes.
So for an example of that, I owned a house before I married my husband, but now we refinanced, and so that would become a commingled.
Well, who refinanced?
We're both on it now.
So you're both on it. Did he go on title?
Yes.
Okay, so the answer is a big fat maybe. Okay, depends on what the intent was. Okay, the Court of Appeals in the state of Utah is divided over this on what happens in those exact situations. If it's very clear that your intention in putting him on title was to give him the joint marital interest in that property, then yes, it's probably marital property now. If
I
you
think
can
the
show.
intent was to give me the whole thing.
Oh, she's now rethinking that.
I just want to know how to go.
Well, I'm glad we're having this conversation. If your intent was not, and there's something we could show that showed that it wasn't, then he might not be getting a full half interest in the property. Okay, so it's fact intensive. It's again, it comes back to like, it's not as clean as it's community property 50-50. It's not, like, it's way more fact intensive here, okay? So when we're looking at these equitable distributions, let's just say everything that this couple has was acquired during marriage. It's all marital, okay? And now they're getting divorced. They have a house, so they have two vehicles that are worth exactly the same. They both have retirement accounts that are exactly the same. How's the court going to divide it in an equitable distribution state? It's a trick question. So we don't know.
However they want.
No, the judge.
What are attorneys probably gonna tell you? What are you gonna find if you go on ChatGPT and you ask it? It's probably gonna say it's gonna be divided 50-50. That's usually, okay? Because it's not every time. We're not in a community property state. Because the court has equitable powers. They can take other things into consideration. Anybody have any idea what kinds of things they can take into consideration if they're not gonna be equal in the distributions?
Yes.
Children certainly could be a factor, right? And in what way?
Child support,
Well, so child support's getting paid, that's out of income, okay, so that's not necessarily gonna be affecting the asset distribution, the asset, the house, it can affect the house, right? If the court determines, well, you know what, it's in the best interest of these kids that one spouse stays in this house and they get more time before they have to buy the other side out, or that would be too burdensome, the court could decide to do something a little different than 50-50 or substantially delay it. Okay, it's not as common today, but it used to be that, let's say it was a stay-at-home mom, getting divorced, she's in the home. It used to be that many times the court would say, you do not have to pay the equity out to the husband until the youngest child turns 18 and graduates high school. That would not happen in community property state, okay? But equitable distribution did. Now, it doesn't happen as frequently anymore. More often now, they might give a little bit of time, and more often now we're having two-income households, so it doesn't happen as frequently. It's fallen out of favor, but that's just an example of how that could happen. It doesn't necessarily need to be equal. It also might be the case with, if you are selling the house, right? And the proceeds from the house could be divided 50-50, and normally it is, but doesn't have to. Because they could look at it and say, hey, okay, we have one spouse that got a great job, great education, gonna be making a lot of money going forward, and yeah, maybe there's alimony, but we're also gonna take that into consideration to say the other spouse should get a little bit more of the equity. They should get a little bit more of the retirement account. They should get a little bit more of the other investments. The court can do that. You also have other factors, things that can affect it too, like if one spouse did things during the marriage that substantially negatively affected the finances of the marriage, right? Gambling, right? They're out to a big gambler and they're losing a bunch of money. The court could be like, well, you know what? You gambled away a bunch of money, John. We're giving a bunch more money to your soon-to-be ex-wife. All right, that's just the way we're doing it. Okay. So equitable distribution can do those types of things. Yeah.
On the other side, is it your experience that if one of the spouses has a career that's far exceeds 40 hours a week and the other spouse doesn't work, that the spouse with the career may get more than half?
So the answer, I'll bet anybody in here could probably give the same answer that I'm gonna give you right now, which is It depends. Classic attorney answer, totally depends. Depends on what else is going on in that situation, depends on whether assets are there, depends how long they've been married. Depends on what the other spouse's ability is to progress in whatever profession they might jump into or have, or if they gotta get more education. So there's a lot that goes into it. So really, really good question, but there's just not a good answer for it. Okay, what else?
I had a client once where his girlfriend convinced him to put him on a title of a house that I was helping him to
Okay.
acquire. Not married.
Yep.
I advised him. I said, you can press a beneficiary if you want, whatever, because you can take it off anytime but this relationship may not happen, and, if you put on title, she's entitled to half of it. Is I right to say that?
The answer is.
Depends.
Depends.
See, well.
Yeah, one of the things that's interesting, so our topic today obviously is equitable distribution versus community property, that's what we're talking about. One thing for maybe a future meeting is to dive into the world of people not being married and
Okay.
what the heck do you do, right? Because that is way more common. I heard just the other day that for the first time in a very, very long time, the divorce numbers are actually going down. And why do I think that's the case? I think it's because less people are getting married. And I think what's happening is a lot of people aren't getting married and then they're buying houses together, or they're adding their boyfriend or girlfriend to the house. And now suddenly they're gonna end the relationship and we don't have a divorce action to deal with that house. Because you can't do it in a custody case, okay? If they have kids together, the court has zero jurisdiction over a house that those two people happen to own as tenants in common or joint tenants. They just don't have jurisdiction. So what do? Yeah, the answer is it's a big giant hole in the laws across the country, but certainly in Utah. And we got to get it figured out because right now there's a giant hole for it. But again, I digress. So
So
I think-
with that, we're gonna be creating a lot more questions and answers today.
sorry guys, I got us going on questions.
Okay, so a few follow-up questions for you. So what are some common types you'll see in division of the property? Like, do they force to sell, they split? What are some things that you normally see as a way for someone to divide that property?
Yeah, Chuck kind of hit it, right? Sometimes it's gonna be a forced sale. And if that's gonna be the case, it's gonna be in short order, right? If it's a forced sale. The other way is if one party really wants to keep it, they're gonna have to find a way to pay equity out to the other side and to get their name. The court's just not gonna make them stay on that mortgage forever. It's not gonna do it. And that sometimes is really difficult to do, right? Because especially like right now, the conditions with mortgages, right? What are we seeing a lot? Well, we're seeing people that have mortgage interest rates of 2.5%, 2.75%, 3%. And if they gotta go refi or get out a bunch of equity, what are they at? What are they at today? 7%?
6.5.
If you're with Robert, it's 6.5. Okay, everybody else, 7.5. Okay, we're not calling you, but that's what makes it challenging. And so right now, oftentimes it's really difficult to get to the place where it could be that one side buys the other side out. But that's almost always what it's been. If it's not sold, if it's not a sale that's going to happen, then you've got to have some way for there to be some kind of buyout if there's equity, right? But also parties can agree to whatever the heck they want, right? In a mediation Joey did today, parties could agree to anything they wanted to as far as the house goes, and the court wouldn't care. When the court signs a decree of divorce, they are not looking at the real property provisions. I can promise you that, right? They are way too full with way too many things. They look at one thing when they look at a divorce decree, if they're gonna sign off on it. Do you guys know what it is? Kind of, related to children, you said children. So related to it, what do? What is there usually when there's custody? Child support, right? There are child support guidelines that have to be followed, and so the court will look at the child support to say, did it follow the guidelines to a T? If it didn't, I won't sign it. If it did, I don't care what it says about the real property. I don't care what it says about any of their assets, right? So parties can agree to anything, but it's usually either for sale or some kind of buyout and then refinance.
So to follow up on that, so if somebody is trying to get the other person off the title, but not refinance, so it's a HELOC, right?
Mhm.
What's the process? Or maybe this is a question for you.
That is a perfect question for Robert. No, I mean.
So what was the question?
You don't do a refinance, HELOC, right? So you pull out the equity, you give the equity to the developer. Now what happens on title?
Are they staying in the home?
One party does.
Yeah, so who's staying in the home? The party that took out the equity to pay the other off?
Well, yeah,
Yeah, so what about the primary mortgage?
so how do you address their title?
Well, what are we doing with the primary mortgage, right? That's the question. So if the one spouse is buying out the other,
The mortgage stays, yeah, so what do you do,
Yeah.
what do you do with that, the existing mortgage?
So yeah, you gotta, so as you probably know, I mean, they're gonna arrive at an agreement when they have to sell that property.
or when the name has to come up for the primary mortgage,
Yes,
right?
yes, right.
Which could be through any number of ways. It could be a refinance, but it could also be an assumption. We've seen a lot of that these days, assumption of the
Yeah.
primary mortgage to get the name off.
Ideally,
Because the other spouse, like, shouldn't be staying on the mortgage, and certainly not on title. But oftentimes in the divorce, this isn't, Roger's got his own thing, but for the divorce court, what needs to happen is, once that time comes, that needs to happen, there needs to be the correct either quitclaim deeds or warranty deed signed to go, and deed the interest of the spouse that's keeping it, right? It needs to be clear. We have to have clear title, and that's some Joey's realm as well, but, and then prepping it for whatever you gotta do on either an assumption or a HELOC or a refi.
yeah, it's probably a good segue, I don't know.
This is, we're right on. It's your turn.
And look, this is like, these guys, man of the hour, like my part is super simple. My job is really just to draw your attention to some of the things that maybe people don't think about. And if you're talking to people, and obviously, hopefully way before they're making the decision, or somebody says, hey, I'm looking at buying a home, I'm thinking about going to divorce, I don't know. These are some of the things that you guys probably want to be making sure that your clients are thinking about way ahead of schedule. Because when it gets to here, chances are everything will be mitigated, everything is going to be, but the further you can make decisions, financial decisions to help you in this situation, the better. Right? So, I made a couple of, and feel free to, check in with me at the end of the discussion. I can give you I can email you a copy I just made a couple of notes, as it relates to credit, mortgage and home ownership options, qualifying for a new mortgage. Both parties in theory need to be qualifying or not, right? And then planning for the future. And I don't like sitting, by the way. I'm
I was
sorry.
gonna stand, but I didn't feel like I could. Josh was like, no, you're sitting here.
Josh,
You're there,
listen,
I started standing.
this guy's dressed to the T, he looks way better than we do, and so he's like, Josh is like, hey, have him sit down. We can stand, so we'll look maybe a little bit better, but, so just a couple of things, and obviously feel free to ask questions or interrupt me, but, so from a credit and financial standpoint, one of the very first things that both parties want to do, and you'll want to make sure that they've done, is that they've established their own credit. Because sometimes you'll be surprised, we do live in Utah, and I don't mean that necessarily as a negative, but there's obviously a lot of mothers that work in the home, right? And not outside of the home. And sometimes, and we see this all the time from our perspective, a husband will come in, he's got the job, he's oftentimes will just apply for the loan on his own, and then he'll put the wife on title after the fact, but not on the loan. That has an effect for the wife's credit in the future, for better, for worse. Mostly for worse, but for better if in fact, if he chooses not to make payments, then she's not right on the loan. So those are some things you want to make sure and tackle beforehand, is make sure and separate and make sure that if you are thinking of going through a divorce and you don't have a lot of credit, you got to start building. I've got ideas on how to do that if you have questions later. One of the other things is that you want to make sure and close or remove yourself from joint credit cards. So you're thinking about doing this, you want to go ahead and get that done beforehand. How many times have you had a situation where we get to the divorce table and one party has gone and just used up all the credit cards and done all kinds of crazy shenanigans?
I would love to tell an anecdote right now.
Go.
I have to tell this one, guys. It's one of my favorite stories. Okay, I'm in mediation, okay? And we're going through the credit cards, okay? And the other side hadn't given us all of their disclosures like they're supposed to before, so it was a little bit annoying, but we got it. So we're in mediation, separate rooms, okay? So we're not in the room with this person. I'm representing wife. We suddenly get these disclosures, and then suddenly we're looking at about a $20,000 Victoria's Secret credit card. Okay, so we're like, that's weird. I'm like, is this yours? She's like, No, it's not. So he's pretty pissed off, right? Okay, but here's the tie, so you think that was, you think that was marital or separate? Separate. So I thought so, because I thought it was for a mistress.
That's what I thought.
Turns out it was for him. So it was marital. Okay, that's the end.
I wonder why they got investors.
So we'll be looking for stories with each one of these, with each one of these. A couple of other things is avoid taking on new debt until your financial situation stabilizes, until you figure out, really until you've gone through this process and you've gone through the mediation process, don't incur any new debt, right? And establish individual credit if you do not already have it. How can you do that? Several ways to do that and ideas on how to do that without taking on additional debt. So there are several ways you can do that. Next thing, so again, we've talked about this already. Decide if one party or both, are you gonna sell the home? Is somebody gonna stay in? How are we going to accomplish that? The quicker you can get your clients in front of a mortgage professional such as me, there's no one back there in the back, the better. You want to find out, we need to find out if you're staying in the home, if you qualify on your own, okay? You also want to find out if you're vacating the property, going to a new property, how much property you can afford. So the quicker we can sit down as mortgage professionals with your clients, the better. We will help alleviate a lot of concerns and create and remove a lot of doubt with that step. Another thing, let's see, if you're keeping the home, determine if a refinance is needed or remove the spousal mortgage. We talked a little bit about that in this situation. And then understand that a divorce decree does not remove financial liability. You must refinance or sell to separate responsibility. I had a question today come from an agent, and the question was, can the spouse stay, or the spouse is not on the loan right now, is on title. She is staying in the home, believes she can afford both the first mortgage and the second mortgage. Her idea is that she wants to refinance the first mortgage because she has 1 year to do this. She wants to refinance the first mortgage, but not the second. Not exactly sure why, but she can't. That's her idea. So I was called with the question, can she just refinance the first and keep the second? Well, the answer to that question in a normal world is yes. You can refinance the first and subordinate the second, meaning that the second will remain second and refinance the first. Because immediately when you pay off the first, what comes in first position? The second, right? So we would have to get a subordination agreement in a normal world, refinance the first, keep the second. Most all financial institutions will do that, especially those that do seconds, right? So that's not a problem. So she's thinking she can do that moving forward. I don't know exactly why, what her reasoning is for that, but that cannot happen. So if she has to refinance the first and the second in order, and has to be able to qualify for both all that debt, including whatever she needs to take on to pay off the spouse. So that's a sticky situation. And again, the faster we can get in front of your clients, the better. Alleviate any concerns. And then if selling, assess market conditions and potential capital gains. Here's where our realtors come in handy. You guys come in handy, right? Is to help identify what the price is today. What was, did I have a question? Obviously qualifying for a new mortgage, that's gonna take a lot. So again, the quicker we can do that. There's a lot to consider. You guys are all familiar with DTI, all that kind of stuff. So I'll forego that. And then planning for the future, you got a budget for housing expenses, including insurance and property taxes. A lot of people forget about that. Update your estate plan. Again, we've got these guys here that will probably do that. I'm sure you guys do that in conjunction with the divorce. And then lastly, work with a financial planner in addition to somebody like us. I just happen to be both. I'm not a quote unquote certified financial planner, but I do have access to a wealth of friends that are still in the business that we work in conjunction with. But the quicker you can get the financial side, the better. That's probably the stickiest situation in this, or one of the most stickiest situations, is my guess, and you guys can correct me, is the finances, right? How, where, what, the faster we know, the better. The earlier we have bad news, and I say bad news with financial news, right? Because now we're taking on either all debt or, and now I gotta pay alimony or I gotta pay child support. The quicker you know that, the better, the faster you can plan, the better your plan will be moving forward. Any questions?
I got one. I know assumptions you can do with like FHA pretty easily. It sounds like I've got one that's a conventional and they said with a life change, it's a possibility.
It is, is
It's
it?
a case by case
Okay.
lender,
I
yeah.
had it, my client, I had to help her, but, yeah, she was able to do
So are
it.
you
Yeah.
actually wasting time with this or you're just pushing me off? But that's good to know.
Yeah, no, yep, can happen. Yeah, and that's ideal, especially if they advanced or purchased several years ago, right?
Yeah, in the twos. I'm like, don't let that go. Please.
But, you know, sometimes if you add a second into the equation, well, now we gotta figure out, because the seconds sometimes are 11-12%, right?
Sure.
So if you got a 4% and a 12%, you may be better off refinancing at 6.5% or 6%, depending upon where you land. We'll do the math for you, right? So, yeah.
Also on that, talking about assumptions, timeframes for assumptions. How quickly do assumptions take place from your experience?
It's probably gonna take a good 60 days.
Hers took 6 months.
Oh, yeah, so-
It took forever.
Yeah, they're not fast.
It ranges on the
I don't think they
mortgage
were.
provider. So whoever the servicer is, if they know and they have an actual assumptions department, they're gonna be much better at it. I've dealt with a lot of companies that had no idea.
Yeah, some servicers, and remember, your loans often get sold, and some servicers are better at this than others. And, yeah, you don't wanna be with some servicers that all their, especially if they don't have like a very good website. I mean, that's your first clue. But yeah, some servicers remember, they exist to keep your loan the way it is without any changes, right? The last thing they wanna do is change things.
Now,
So that makes it
to go on
difficult.
that too, with a traditional refinance, there's gonna be better compensation for these mortgage companies. When you do an assumption, it is a minimal cost,
Yeah.
very minimal, and it's a huge headache.
Yeah.
So the companies will try to make it difficult and try to avoid responding in hopes that you give up, or in hopes that you're gonna push to get another financing deal done through the work. So just know that if your clients get frustrated, you can get in touch with an attorney. It's happened to me. I had a client who was getting the runaround and the other company said, no, we don't have to do it. I said, yes, you legally do. It was a VA loan, we actually got the VA involved. They hired an attorney, they got sued. Now everybody was getting their stuff done. But what you do need to understand that it can take longer. They don't know if there's mess ups on paperwork. It can take 6 months, even longer than 6 months. So if there's a deadline on when to do it.
Yeah.
That assumption may not make sense, especially when you're getting a second with the higher interest rate.
All things to consider upfront.
I was just gonna say, this is something I've been thinking about recently that was sort of reemphasized, I think, in what you just said. I think there's a lot of value in strategic partnerships for us as realtors. And so, for example, obviously mortgage broker, but also a credit repair specialist or job placement agent, right? For these people that are going through divorce, they're gonna need to work on, sometimes they'll need to work on their income, right? And get a job or a higher paying job, work on credit, whatever. So I think we can provide more value as we have those strategic partnerships in place.
Yeah, I would agree, and especially, you know, most of us mortgage professionals have access to great credit repair specialists that we work with. And they can help not just repair, but also help build. And so we have lots of ideas to help in that regard. But yeah, I would wholeheartedly agree with you. Having a team of people that you can trust. And by the way, I mean, I get calls. I mean, if I'm awake, you know, at 11 o'clock at night and I get a call from an agent, I will answer the phone because I know they have something that they want to answer that need answered now. I will do calculations over the weekend, at night, whatever the case might be, to help you guys have better answers so you guys can help service your clients better, so.
Tonight, I'm at 11:30, text this guy.
Don't be texting me at midnight.
Hey, listen, and my process is the same thing. She may not answer me at 9:30 in the morning, but she works with me at 11 o'clock at night, so.
I can vouch, it's happened before.
Yeah.
Been there.
All right, so now we're gonna move on to Joey. He's gonna be talking about legal and title considerations. But that, you can sit down or stand
No,
up.
I'm gonna sit. So,
He's too tall, but he stands up, he hit the ceiling. So it's like,
yeah, you know, I think we'll have kind of a conversation with this. The legal and title, you know, considerations with divorce are really kind of where the rubber hits the road. It's kind of the practical effects of what happens in divorce. So raise your hands again. How many of you guys have dealt with people getting divorced, selling a house? So it was like almost everybody, right? How many of you guys, the same people, had problems with something divorce related, meaning both people are on the title and we're trying to, so it's, these are common things. Why do they become so common? Why do they happen? Well, let's start with, there's probably two main culprits of it. One, not everybody that gets divorced uses an attorney. You guys know that, right? Some people will file their own divorces. What does the language look like in a self-filed divorce, do you think? Yeah, laughable is right. Yeah, I mean, there's some of it, it just doesn't, it says, okay, party A will keep the house. Done, we're done. Party A keeps the house, great, so all problems are solved. Well, it doesn't address both people on the title. So then, okay, so both people, party A is gonna keep the house. I need party B to sign a quitclaim deed, right, to give it to the other side. How well do you think that's gonna work? They're getting divorced, they don't like each other, right? They're not, it's not always that pleasant. Well, let's talk about if you do have an attorney. Okay, so how many lawyers do you think go into a mediation with the consideration of how we're going to actually get that part done? Or are they also going to sometimes look at things and go, okay, party A gets the house? Lawyers go to law school to be lawyers, not to figure out all the different ways we're gonna separate assets. The better lawyer is gonna handle this stuff, but really, once a lawyer's done, we're done, right? It's really not your problem. And that's how some attorneys unfortunately look at it, is like, okay, we got through mediation, which 90% of your divorces that are handled by lawyers are being done in mediation. How many times do I go into a mediation where there's not even been an appraisal done on the house? Common, pretty common. Now with our clients, we make sure that we have them. We have good relationships with people that will get us, you know, the things we know so we can go in there with it. But it's not always common. And so what ends up happening on your end is, okay, the divorce decree says party A gets it and the other side has 60 days to sign off on a quitclaim deed. What if they don't? How many of you guys have dealt with that? What if you don't? What do you do then? And how does that affect your sale, right? It slows it down, it can kill the whole deal. Because what does the other side got to do at that point? They've got to go back to court, they've got to ask the court to enforce. There's all these steps that can happen that make it really, really ugly. What about liens on the title? So, okay, party A gets the house, we're gonna sell the house. How many of you guys have had and found out, oh, there's a lien on the house?
Yeah.
Party didn't disclose it,
Yeah,
right?
yeah.
It happens.
You pulled money out to put it in crypto,
Yeah.
wife had no idea.
Yeah.
And then now
That's
the
right.
crypto tanked.
And,
It was just
and we
like-
didn't happen to mention it in the divorce.
That sounds like an equitable distribution problem to me. I think, Tom Brady, was it Tom Brady or? No.
So,
Sorry.
Yeah, so in a perfect world, you've got two competent attorneys working with parties that have disclosed everything and done that, and we've handled all this, but that's not how it always works. And so then you end up with, how many times do you do a title search before you actually say, okay, we'll do that? Well, that's what we'll do, right? Like, a good attorney will do that, but it's not always what happens, right? So this is where it becomes problematic, right? You guys end up with the mess after the fight, right? Things are signed, what do you do about it, right? The idea is we're trying to get clean title. That's ultimately the goal, is that when the divorce is done, in a normal amount of time, the parties have the language in there that says, we're gonna have a clean title. We're gonna have done a title search. We're gonna have, we're gonna have one party sign the other off. We're gonna do an assumption. We're gonna do whatever it is that needs to happen, and we're gonna have a time frame on that. The reality is it doesn't always happen that way. And so what are the recourses you guys have? Those of you that have had those things happen, what do? What happens?
I always approach the defaulting party and whatever I have to, I mean, try to spend enough time with him to try to find an entry. You can always let him know that they're in breach of that agreement and that if he signs this within, he can come to the bank and sign this document with me right now, then he'll be in compliance and appreciate your time.
So,
I think, oh,
yeah, go ahead.
I think a lot of times they won't sign because they don't have their money in their hand yet. And they're like, well, it takes a little bit more process. Once you sign that, we've got to finish underwriting or close the loan. So I think a lot of times that I had that happen. And so we just had the title company reassure them and then we were able to get them to sign. Like,
And
you'll get
that's
your
what it comes
money.
down to, right? Is it comes down to some prodding, some working with people. This comes down to just kind of life skill stuff, right? You're talking to people. This is your job. One of the things that I will tell you is what we really focus on, I would say, is there's a lot of relationships outside of the legal relationship that matter in a divorce, right? So when we go into a mediation, we have relationships with, you know, people that are doing the mortgage. We have relationships with the realtor. Why do we have relationships with realtors? Well, because in the mediation, you think they're gonna agree on on anything, right? How often? If we can come and we can say, look, we have a realtor that will be fair. Now, a lot of times they say, well, I've got my realtor and you've got your realtor. And sometimes we have some middle ground. But having relationships with these people from the attorney side is really helpful. And I would say the same thing to you guys, which is you should have relationships with family law attorneys because you may come up to a couple that goes, hey, we're gonna sell this house. We've done the divorce ourselves. And you might go, have you thought about that? Because there's language in here, there's things that need to happen. So a lot of this conversation is, you know, it's rubber hits the road. You're gonna deal with divorce a lot. Like it's gonna happen. If you're a realtor, you're gonna deal with divorce. And what you're really looking for is, what questions do you ask and what are you really looking for? You're looking for clean title. And that's not always that easy to tell because they might have a divorce decree, but a divorce decree is not always the same as an actionable, you know, clean title. So with that, guys, like there's not a lot on this subject that's outside the wheelhouse you guys have had, but what have you guys seen? What are the concerns that you guys have that you see in this with clean title?
Well, maybe not clean title, but if somebody isn't willing to sign and they do have to go back to court, what is like, how long does that usually take? Estimate? Like if you need to do an estimate.
Yes, guys, that.
It depends.
Learning, okay.
It does depend, right? Now, so like today, in the mediation I was in, we put a cap. We said this house needs to be sold, okay? Or reevaluated, but it needs to be sold in 6 months. What happens if it's not sold in 6 months? What do they do then?
Go back to court.
You go back to court. What does that do? That costs everybody more money, right? So you try and be reasonable with this stuff, but at the end of the day, we can put whatever we want in there. But what do? You go back to court.
And one of the things too that you'll see with a well-written divorce decree is it will specifically reference Rule 70. And what Rule 70 says is that if one party doesn't sign a document that they're required to sign, and it has to be brought before the court can sign in their stead. Okay. So in divorce, we file something called a motion to enforce. That's what we call it. It used to be called order of cause. They changed it. Now it's called motion to enforce. You get into court in 5 or 6 weeks. That's about how far it's out, assuming you're in a jurisdiction that has commissioners, which is Utah County, Salt Lake County, Davis, Weber, Tooele, Summit. And that's about how long it takes to get to court once you've got it filed. So once you actually get to that point, that's about how long it takes, but it costs money and all that stuff. But the court can actually sign it in their stead, and I've had them do it. It's a pain in the butt, but it happens.
So it's doable, but it's better if you guys know the questions to ask and know what to look for up front with clients, right? Otherwise, you're getting to the closing and what are you finding? There's a lien, there's so-and-so's not gonna sign, right? It's good to get this information up to people if you know they're in a divorce to ask these questions. So you know what you need to do to get to that closing and get clean title. I mean, that's really what this comes down to. There's a million different things that can come up, but really it comes down to you guys doing fact finding and finding out what that decree looks like. Which seems like maybe a silly thing you'd want to ask somebody that's trying to sell their house, but it matters.
Do you typically include in the decrees like the order of debt payoffs? Considering the liens that are on the property?
Yes.
Yeah, and in every decree.
Yeah, well, yeah, but again, not every decree is done by an attorney or necessarily even a competent attorney. That's why you want to ask these questions, because people that do these themselves, this stuff is not addressed. It will be very, very vague language. And when there's vague language, what does the court do? They need argument, there's all this extra stuff that can go on, and it doesn't happen overnight. Which is again, why if you have clients that are going through this, you want to bring this stuff up with them so that they can get their decree clarified and done correctly. Yeah, it may save them money to do it themselves, but it may not save them money.
Does the court penalize someone, like if they don't sign, like do they get
Sure,
a
they
big
can.
penalty? or-
Absolutely, they can have to pay the attorney's fees for the other side. There are things that can be done.
Yeah, it's called contempt.
Yeah.
You don't follow a court order, you're held in contempt. If you're held in contempt, you can be ordered to pay attorney's fees. Technically, you can be ordered to do community service. You could go to jail. On not signing a deed, I've never seen that, but I sure have for non-payment of child support.
And there are other things. I mean, there's other framework outside of this, which, you know, some of these are breach of contract. If there's damages, if a sale was lost, if there's money was lost, there's other things that you can do. But that's outside of family law, right? As Ryan mentioned, one of the things about getting all of the assets included in the divorce decrees is at that time of divorce, the court has jurisdiction over those things. That's why it is complicated when they're not married, because then you're going into a different court for a different thing. The family court doesn't really have jurisdiction at that point.
How difficult is it to change something in a decree after it's been finalized, like regarding real estate?
I mean, it depends. It's difficult. It can be, it's
You're
depends.
gonna hear all the time, look, we attorneys, okay, we have to hedge.
It just depends.
If both sides are willing to agree quickly, how
I'm gonna
long?
give you an easy, if they're willing to agree, you can change it if they
Yeah,
want.
that's easy.
If they can't, if they won't, very, very hard.
Yes.
When it comes to things like custody, where the court maintains jurisdiction, there's reasons because they care about best interests, you can do it. When it comes to real property or other property, they're very reluctant to change that, but you have got to show some really compelling reasons.
Basically fraud.
Yes,
That's
basically, right?
Yeah.
Or something so outside the realm of possibilities, you never could have imagined that being something that would apply, and suddenly it is. Now, look, COVID probably did some of that, right? Probably had some of that where, of course, we're willing to do some things they weren't normally willing to do, okay? But normally the answer is like, boy, it's tough. You can usually change it.
What about in the case, so I had a situation a little while ago where they had a divorce decree. They had alimony set. And everything was set in a time where business was much better for the spouse, one of the
Yeah.
spouses. And then year two after the divorce, it's much worse, like substantially worse. He can't qualify for a house, he can't qualify for much, and all because he's paying this exorbitant amount of alimony and child support. What in those cases, do you have to, I mean, do you gotta re-engage an attorney in that situation?
Yeah, the standard there is you have to show there's been a substantial and material change in circumstances that was not contemplated at the time of the decree of divorce, right? So that is a common one that does happen, right? Some major change in job, got laid off, can't find another one, or gets one that's way less paying. That could well qualify when you're trying to do something like change alimony, but it wouldn't change the asset distribution. The asset
Now-
distribution would stay in effect regardless of this big job change.
Now, and here's where I also think too, I mean, I'm not exactly sure the capability, and I don't want to call anyone out, but I'm assuming that you get what you pay for, right? I mean, in effect.
Yeah.
I mean, this is why it's important to do your due diligence with situations like this, in particular, if you're guiding your clients and helping them find the right attorney, the right, agents to help in this situation. It's imperative to do your homework and make sure that you're with the right people that know what they're doing. Because I suspect in this case, maybe the attorney wasn't necessarily helping this guy out as best he could.
So to your point, yeah, go ahead.
And this may dovetail with what you were about to say. How would our lawyers recommend we counsel our clients? Because sometimes we get asked for recommendations for attorneys. If we don't have an established relationship with a family law attorney, and even if we do, how do we know if they are any good? How do we do our due diligence on the lawyer?
So, yeah, I mean, one is build a relationship.
Yeah, the same way we figure out if a real estate agent's any good.
Yeah.
Right? It's trial and error, frankly, if I'm being completely honest.
Yeah.
Like, there's times where you think you've got a good one and you refer, and then you look at the feedback, right? When you make a referral to one of your clients to it, then make sure you're following up and knowing how that experience went, but also being willing to give feedback to that attorney, right? If I'm doing something and I make a referral, I'm gonna give feedback to that real estate agent and that mortgage professional, so they know, hey, from my perspective, here's how I think it could have gone smoother. Because that's, if I'm establishing a relationship, it's an important one. How do you find out from the get-go? Well, for family law attorneys, you can probably ask me and I will tell you outside of RCG who's good. And I will be honest with you because I know the good ones and I know the really bad ones.
You can also ask some simple questions, which is if you talk to a family law attorney, who do you use for mortgages? Do they have those relationships? Because one of the most common things, to your point, would be, we go into a mediation and they go, okay, I'm gonna keep the house, I'm gonna get it refinanced. And then I'm gonna give her the equity because I really want to stay in the house, right? And then, separate conversation, okay, I'm gonna give her $3,000 a month in alimony and child support. Great, we've signed it, we're good. They go to refinance it and they're like, you paid her $3,000. Yeah, there's no chance you're doing that. Now we have a decree that says this is what we're doing. And we don't have the ability to do those things, right? That would be a common thing. And again, attorney, if they're like, yeah, well, this is what you guys agreed to, right?
So a good example of this is you guys are gonna guide your clients to what home inspectors to
Yep.
use, right? What home warranty companies to use, the mortgage professionals. It's the same thing. So if someone doesn't know who to work with, imagine if you were an agent and you said, I don't know, go find someone to do an inspection. That's obviously not gonna be someone you want to hire, right? So just the same thing as you guys, what's the reason why someone should hire you as a realtor? Give some reasons, some good reasons why you should be hired as a realtor. Come
Why
on.
do you have so many reasons? Like, whoa, you guys are amazing.
This is not rhetorical.
Like connections and negotiations.
Well,
I thought it was too.
All right, well, what else we got? I issue someone hired.
Somebody that cares, people that.
Okay.
To ease the process of the divorce or the selling of the house, whatever. it's to make it easy
Experience.
for them.
Okay, process,
Like representation of their best interest, research, data, analytics.
best interest, all these are great, and there's plenty more, so I'm gonna stand.
Always stand up. Up, everybody.
I'm only 5'9", so I like the same height as this guy.
Well, he jumps like he's his eyes.
Yes, I do jump high. So, when you're looking at this situation is, are you setting the foundation for your clients early on? Are you giving them fiduciary responsibilities? This is the key word, fiduciary responsibilities. So if you're working with two clients, they're getting divorced. Can you give fiduciary responsibilities to one party and not the other?
No.
No. Do you usually have a good relationship, equal relationship with both parties? Usually you're gonna have a better relationship with one side, right? So what happens if someone doesn't feel comfortable and you're communicating with just one party? What does that do? So you need to actually set the foundation early on with your clients and say, look, I know you guys are getting divorced. I will be communicating with both parties, every single aspect. I'm not your mediator, I'm not your attorney. I'm here to sell your house and get you top dollar. And so I will guide you to those professionals. The moment you start delving into the attorney realm, you are not just breaking your fiduciary responsibilities, but you are also practicing law, which I believe is illegal if you're not an attorney. That's true. So you can lose your license, but you get a lot more trouble. You need to set the foundation very early on and say, look, this is gonna be difficult. You get selling or buying real estate in a normal situation is a highly emotional situation. This is gonna be extra emotional for you two. I am here to give you clear direction, the best way for you to sell your house and get top dollar. Now, what I'm here to help you avoid is avoiding situations where you guys fight and you don't sell the property, and then it becomes a litigation because you have to sell the property, but you guys are fighting with each other. And now you have a third party involved, so you don't just have a divorce, you now have someone suing you to force the sale of the home. So you need to set that early on, say, this is difficult, but just like you're hiring me as a professional, you should be talking to an attorney, because I'm not an attorney.
As far as like the order of operations goes, what's your recommendation on a couple approaches? Ian says, we're getting divorced. We want you to represent us on the sale of the property. We have not yet spoken to a family law attorney. We turn them over to these gentlemen. When you sign the Ursula, what do you do with the listing? Do you take it off market? Like, how do you work through all that while they mediate and go through?
So I would meet with them in person if it's amenable between the two and say, here's the breakdown. I want you to know who I am, this is what I'm doing. If you already have a relationship, then you may not need to do that. Then you want to actually know, you're talking about title, you wanna know who's on title. You wanna know who, so here's an example, this is actually segues into this. We had an agent, they're selling a property, they only had one person's signatures on it. But that's the only person on title, but in the divorce, they still have to agree on the sale of the house. So now it's stuck, and the other party says, no, I don't wanna sell it. Well, they already signed that day, so now they have to go back to court and agree on the evaluation of the home and what it'll be sold for. Now, what they try to do is hold extra money at title to do it, but this one spouse was so upset that the other spouse didn't inform them. Now became highly emotional, less logical. So the first step is, I wanna know who's on title. I wanna know what's the relationship. Do they both agree to use you? I wouldn't have a problem getting the exclusive right to sell leasing agreement signed by both parties up front. Now both have signed. I wouldn't get it signed by one individual, because now you're getting fiduciary responsibilities to one individual and you're not including the other person. And if they come in afterwards, they might feel jaded in the situation. I would do it simultaneously. So the next step would be, you guys really should, there's a lot of aspects that could disrupt your sale and create future legal problems if you don't know everything that's going on with your assets. You need to talk to a professional.
Can I add something there too? What I might ask is like, when are you getting divorced? Are you wanting to sell this house before you guys do it, and you guys are holding off because you want to finish the school year with the kids and you just want to get this done, and you guys are not filing right now? That's different. Because like, oh no, like, I'm moving out this weekend and we get divorced. Like, I can't stand her. Okay, well, all right. Then you're like, okay, we gotta start going down this road of figuring out who they're gonna hire, because
Yeah.
this is gonna be way stickier.
So, and this is a great point, because I've experienced this more than once. They're amenable, we're good, look, we just wanna sell the house, we'll figure out divorce later. But then they start getting into the point and they're like, no, screw this guy, no, screw this person, we're done. But now you're under contract, now what?
Well, so sorry, back up one step, maybe I'm missing something. After the Ursula is signed by both parties, don't you have to have it on the MLS? So do you put it on the MLS and off market? What do you do? Because you are signed up to exclusion.
You can, so it's specific to MLS, you can have, it's the
They're always
it's exclusion form, but you can have it. Wait, it's not necessarily excluding it, but you can say it won't be posted yet,
Okay.
so you're delaying marketing. So you can still get around. Yeah.
Okay. Sorry.
Yeah, but yes, so going back to that situation, people change their minds, especially in divorces. And especially if they find out some sort of infidelity that took place that they weren't aware
That
of.
never happens, Josh.
So, but you need to be super clear and make sure you're communicating to both parties. If you are not, you're in trouble. Go ahead.
Okay, so let's say they are getting divorced, but they are waiting.
Okay.
Husband's on the loan, husband's on title. Wife is not on either. Can he sign and sell without her permission?
Well, did he buy the house when they first got married? So now this is where you're
Okay,
kind of
then
back to, they really do need to talk to you.
Yeah, the reality
The
is-
answer is probably yes.
Depends.
Probably, yes.
But if the
Depends.
divorce gets filed, now what does the divorce court do? Give me that house. That's mine now. Now you can't do anything. Cancel that contract, right? Whatever you're doing, no. Now I get jurisdiction. I'm the judge, so I gotta say what to do.
Yeah, once you file, they put in a domestic injunction in place.
Mhm.
And so then that's when that kind of stops. So if they're going, we're getting divorced, nothing's been filed, yeah, it's more complicated.
Well, and title won't insure the title if you get down to closing and there was a divorce action filed the day before, title will not.
That's right.
But if there wasn't, they'll probably let it.
That's right.
What, by the way, what's that Ursula? Because look, I'm a Disney guy. That's Little Mermaid to me.
Ursula's new. It used to be called the ERS.
So the exclusive right to sell listing agreement, yeah, so.
Sorry.
Acronyms here.
So,
Poor unfortunate souls.
the thing really is, you guys are gonna be emotional in it, right? So coming from my service in the army, I was an interrogator, do body language, train people and stuff. The most important thing is to help people feel heard, validated. Do not say they're right or wrong, and do not act as an attorney. Now, agents are notorious for writing items in an addendum that are strictly legal based, right? Your job in the addendum is to address items in the contract, not to add to it. You're adding to the addendum, you need to have it done by an attorney or approval from your broker. Across the board. So if you're adding any other terms, you cannot do that in there. So bringing this back around is that there's a lot of moving parts in here. You want to know what the situation is. You want to really get them at least talking to an attorney to give them guidance on what's going on. You need to know what are assets, what are the title look like, to give them basic direction. And you need to tell them, I am not an attorney. I can't give you legal advice. First off the bat, you need to they will start relying on you and they keep trying. I tell you, I've been, my sister got divorced, been to a lot of the clients and they'll say, well, you know this stuff, you sound very knowledgeable. I'm like, well, here's something you might want to ask an attorney. You can guide them, but do not advise them. Very, very clearly. Okay, we're gonna open up to the last few questions. We'll hang out a little bit more. We're at the end of our time, so questions across the board, go ahead and ask those now.
You're from Idaho, community property state, and you're single and acquire property. You move to Utah, you get married. You acquire a home here. In the divorce process, what happens to the Idaho property that was community originally? Is it?
It's gonna get dealt with by the Utah court and they're gonna use Utah law to divide it.
Okay.
And where it gets stickier is if you have somebody who's moved a bunch and there's not well-established jurisdiction. And so it might be that you end up doing the divorce in one place by using the laws of the other place, but that's a big mess. I've only done that a couple of times and it's a nightmare. I hate it.
And it's not where you got married necessarily, it's where you're filing for divorce, use the jurisdiction.
If you have one party that wants to file in one state, another party that wants to file in the other.
Depends on where they live, where's the residence. If it's both and they've been living separately, then the courts get a fight.
Got it.
And they get on the phone and then I want it, no, I want it. Literally, the judges talk on the phone for the different states and they have this little conference and they decide.
So which state did Elon Musk file in? Texas or California?
That's a pretty good question. I don't even know. No. Well, it's Texas and California. The good thing there, they're both community property, but deal with alimony vastly differently.
That's cool.
Like Texas, not really alimony. California, woo, lots.
Any other questions you guys have for the panel?
Mini case study for you, so I'm representing a client, like a buyer, I can't purchase yet because his divorce isn't final. His wife were married for 20 years, very early in the marriage, they bought this house. And at the time, you know, their incomes were kind of similar. Well, a few years before, they're kind of pretty similar. By the time they bought the house, her business had taken off exponentially. And by that point, her income was multiples of his. Years later, her income would become 20 times annually his, correct? But they bought this house. The down payment was commingled funds as far as anybody can document. But realistically, it was her money, you know, her business had taken off at that point. They wouldn't have been putting $500,000 down on
Business from prior to the marriage or business she started
during the marriage. So now they own this house, so now it's worth, you know, $2.5 million or something, and based on the history, what should he expect his ownership, interest, or distribution to be?
He should expect an equitable distribution, and the answer is. But what I'm gonna tell you is probably 50. Because even though, look, she started the business during the marriage, so what does that make the business when it comes to divorce? It's marital. Right? All the income she made from the business, what's that during the marriage? Marital money. So it's not her money she put down to buy that house. It's marital money that she put down to buy the house in the eyes of the divorce court. It doesn't really matter that she did it from her business. It's a marital property. It's gonna be divided 50-50 in all likelihood. But again, somebody could make the argument for some unequal distribution for whatever reason. They don't usually do that. That's the thing. We talked a lot about like, it depends. Most of the time, it's 50-50 in Utah, most of the time.
All right, that brings us to a wrap. Now, I'm sure you guys have lots of questions. We do have business cards for both Ryan and Joey up here. Very knowledgeable, and you know, they're good golfers too. They thought it was good to have me golf, and they realized how good they were afterwards. But if you have more questions, please reach out to them. It's good to have someone in your pocket to send your clients to. You should not be asking this question. So thanks again to Ryan and Joey for coming and joining us today on the panel.